You're right.
Thank you, Mr. Chairman. Mr. Delaney, I want to pick up where Senator Blackburn left off. In your filings, in not wanting to allow the victim to maintain her anonymity, you made the following argument in writing, quote, "A court must balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant," close quote. I'm not aware of any precedent that supports this position. It does, moreover, appear to contradict every norm in any courtroom in America with regard to a child victim. I'm not aware of any courtroom in America where a child victim, whether still a minor at the time of the trial proceedings or not, where the victim wouldn't be allowed freely to choose to protect her anonymity. So I'm struggling with this. Can you please explain to me how it is that you think, or that you thought at the time? And normally I defer to nominees in the sense that when somebody has a client to represent, they make arguments. Those arguments don't necessarily reflect the attorney's personal views. But there are some circumstances where lines are crossed, and where an attorney goes beyond the duty and the professional obligation of providing zealous representation and steps into some really murky hinterlands, to put it charitably. Can you please explain to me where you got this formulation? Here you have to balance the interest of any prejudice to this ritzy elite boarding school against a child victim who was still a child at the time of the trial proceedings. Can you explain what balancing that is, where you get that, and how you thought that it was even a decent argument?
Thank you for the question, Senator. As an advocate, the school did agree to allow the family to proceed. Well, how anonymously.
Kind? It's not something that they bestow. Yeah. This was something that you were trying to stop, a right that she had that you were trying to foreclose.
And what we did in the case, Senator, is we provided Judge Barbadoro in New Hampshire with an order that had recently been issued by Judge Walton in the District of Columbia, where he had both allowed the sexual assault victim in the case to proceed anonymously, while he simultaneously placed restrictions on the lawyers from speaking about the case publicly. So we asked Judge Barbadoro to adopt a position that had recently been ordered by the federal district court in the District of Columbia. In addition, Senator, there has recently been—
That was not at the same time you were making this argument, that the victim's interests have to be balanced against the risk of prejudice to the institution, an institution that, according to the allegations, and as I understand the facts, an institution that was aware of this senior salute, aware of the fact that it had not just become a tradition of debauchery, but of child sexual predation. What interest is there to balance there?
Senator, the Prout family had just a very strong interest in proceeding anonymously. There's no question about that. The school was asking the court to restrict trying the case in the media while that anonymity was being respected by the court. I will note that if I were confirmed to be a judge, there is recent case law that has been adopted by the First Circuit on this very issue as recently as August of 2022 that sets forth a standard I would be obliged to follow regarding the use of anonymity in court.
Well, yeah, that's great, and I'm not worried about circuit precedent at this point. I'm worried about the argument that you saw fit to make, and I find the argument that you appear there to have been making against anonymity of a child sexual victim who was still a child at the time the trial was taking place particularly confusing, when in another high-profile case involving child sexual assault victims, and the Boy Scouts of America, it doesn't appear that you ever objected to the use of pseudonyms to protect the privacy of plaintiffs, who at the time had reached adulthood, unlike Cassi in this case. So how do you account for the different approach in the two cases, one involving a minor female plaintiff, still a child at the time the trial proceedings were taking place, and the other case in which there were several by then mature male victims?
Senator, I don't recall the specific case you're referring to involving the Boy Scouts of America. I would like to simply acknowledge your point that I agree that under existing precedent, it is perfectly appropriate and so necessary for survivors of sexual assault to have the opportunity to proceed in court anonymously.
Okay, my time's expired. I just want to ask one yes or no question, be very, very brief. So, do I understand you now to be denying that you tried to deny the victim her right to anonymity? Or are you saying you did not do that?
I am saying that the school assented to the family proceeding with anonymity
After you had made this argument?
provided that the judge imposed conditions against the lawyers trying the case in the media.
But that's not the argument you were making there. Thank you.
Senator Tillis. Senator Welch. Senator Lee.
Thanks to all of you for being here today. Judge, Mr. Papillon, let's start with you. Got ahead of myself there. Tell me about the EIE Doctrine. What's your understanding of that doctrine?
Thank you, Senator. The EIE Doctrine is a doctrine that when a federal district court is sitting in diversity jurisdiction, it applies state substantive law, and it applies the federal procedural law, the federal rules of civil procedure, the federal rules of evidence.
What's worse, in your view, invalidating as unconstitutional a statute whose unconstitutionality is sketchy, or upholding a statute whose application is in fact unconstitutional?
That's a difficult question, Senator. It obviously, if a law is unconstitutional, it is inappropriate and is something that should, going back to Marbury versus Madison in a different context, obviously.
Let's suppose we're talking about an as-applied challenge. It'll make it a little simpler.
Yeah. Can you tell me what you're asking?
An as-applied challenge, meaning it's you're not dealing with something that's facially unconstitutional. So what's worse in that circumstance? Upholding the application of a statute as to which it might be an unconstitutional application and is, or improperly holding something unconstitutional as applied when it's not. Is either one more defensible than the other?
I don't believe either is defensible, so it's hard to, when things are indefensible, it's hard to rank them. So I would say they're both wrong.
Yep. A few years ago, there was an executive order issued by Governor John Bell Edwards dealing with COVID in a lawsuit involving Pastor Tony Spell. The pastor argued, among other things, that he was protected by the First Amendment and that the law shouldn't apply, couldn't apply to his decision to hold church services. When you were asked about this at oral argument, you were reported to have said, quote, "The law is not about one person, whether a pastor or a churchgoer. We're a nation and a state of laws." Would you make that same argument today? Yeah, or was that, did you in fact make that argument?
That sounds like a familiar argument. I think I would argue a lot of things differently, I think, in that particular case. That was a very difficult and challenging case for the state of Louisiana and for religious liberty, Senator.
Okay. You said that sounds like a familiar argument. Sounds like something you might have said. In other words,
Yes.
Why is that appropriate? I mean, the First Amendment is there almost entirely for people making the argument as just one person, as the challenger. The whole reason we even need it is because it's there to protect people in expressing unpopular beliefs, in believing unpopular things. And so I don't understand why you would think that was a good argument to make, that the law isn't about one person. We're a nation and a state of laws. I mean, that's the whole point, is to, in some circumstances, penetrate the law to protect the individual, is it not?
Senator, in that particular case, to add context, this was a case that the state of Louisiana brought against a man of faith during the pandemic.
Who just wanted to have church. He
Yes.
wanted to have church services, and you prosecuted him for that.
And there was an executive order issued by the governor at a time as you're aware, when the Lukumi decision and the Jacobson versus Massachusetts decisions were not necessarily in that particular context the most helpful tools for states. And my role
Right, not the most helpful tools because they went against the state's interests.
in some contexts, but in other contexts, the Fifth Circuit, for example, used it in another way. And so when states were forming their response on the ground, it would have been wonderful to have, for example, the benefit of Tannen versus Newsom at the time that this prosecution was brought.
Okay. That part is concerning to me because it's the whole reason we've got them. It's the only reason we have them. Judge Hersom, what's the standard for diversity jurisdiction?
In federal court, the diversity jurisdiction, forgive me, I pledge not to do that. In federal court, the parties need to be from separate states, and the amount of controversy needs to be $75,000 or more.
Okay. Thank you very much. I see my time's expired.
Thank you very much, Senator Lee. We're going to make an exception to our procedure because our colleague, Senator Blumenthal.
Chairman.
Thanks, Senator Rono. Senator Lee.
Thank you, Mr. Chairman. Thanks to both of you for being here. Judge Alba, in the case of United States versus Tanner Joel Hernandez Fields, you sentenced a defendant who had pled guilty to child pornography charges. Now, the initial pre-sentence report prepared by the Office of U.S. Adult Probation and Parole recommended a sentence of 111 months. And a later report recommended a downward departure from that, a sentence of 66 months. The guidelines range was 78 to 97 months, and hence the downward departure. Now, the prosecution noted, disagreeing with the second pre-sentence report, that the defendant's conduct revealed that he was an extreme risk to minors, given that he had demonstrated a sexual interest in minors even after having been arrested by law enforcement and having been subjected to the criminal justice system as a result. And they went on to explain how he had repeatedly acted on his interest in minors. They pointed out, moreover, that they disagreed with the second pre-sentence report and the recommendation for the downward departure based on the fact that there was a discrepancy and a discrepancy between what the defendant had said to some people and what he had said to others. Here's what the government pointed out. Quote, the discrepancy between what the defendant apparently told the probation officer who prepared the pre-sentence report, that is, that he does not have a sexual interest in children, and what the defendant previously stated to law enforcement and the psychologist who prepared a report of his defense, to whom he said that he does have a sexual interest in children and was in fact comforted by viewing child pornography. Now, can you explain why you made the decision to depart from the guidelines, notwithstanding this discrepancy between what he had admitted to the psychologist and what he claimed was the case to the probation officer preparing the report?
Senator Lee, as I mentioned earlier, I am required to look at many factors when I sentence a defendant. Anytime I impose a sentence, I'm required to look at factors under 18 U.S. Code Section 3553A. The Ninth Circuit, as well as Supreme Court precedent, also require that I look at, as you stated, the pre-sentence report. I also need to look at any requests from defense.
Sure, yeah, I understand that.
The
I'm just
victim.
asking about this case. So.
And I know, Senator, that you mentioned that there was the discrepancy there because he said before, I'm not interested in kids, and I am interested in kids. I don't recall that that was the reason for the request for departure from probation. So I don't think probation believed him, and I don't think that that's the reason why they requested the downward departure.
He sexually assaulted a child, and you gave the downward departure, notwithstanding the fact that he admitted to this ongoing, he admitted to and engaged in conduct consistent with his ongoing sexual attraction to minors. Do you recall your basis for the departure?
No, Senator, what I was saying is I got the impression that you were explaining to me that the reason that probation departed was because he said he wasn't attracted to minors, and that was not my understanding of why they requested
what was
for the
your
departure.
reason? What was your reason?
So, Senator, I look at everything. I have to look at everything that's presented to me, and it's after looking at everything that I make that determination. I have to do an individualized assessment of every thing that comes before me. And I can tell you as an example, 2 or 3 weeks ago, I sentenced a different defendant who was sexually trafficking minors to the full amount, which was, I think, 232 months at the time. So it's an individualized assessment. There isn't one specific thing that, changes my mind one way or the other. I have to do what the law requires me to do, frankly, what the legislature requires me to do, what the Supreme Court requires me to do, and what the Ninth Circuit requires me to do, and that is to give an individualized assessment to each defendant in each case.
No, I understand that, but in order to downward depart, you've got to find something about the case that takes the case outside the heartland. Here you have a child sex predator who sexually assaulted a child. So that's what I want to know, is what was it about this specific case that took this case outside the heartland, warranting a downward departure?
I don't recall specifically what it was. I do recall that it was, if I recall correctly, I believe I sentenced him in line with what probation requested as to the second report. But I don't recall what the downward departure request, what the basis was.
Okay. I see my time's expired. I may ask you about that and a couple of other things in written follow-up. Thank you, Mr. Chairman.
Thank you, Senator Lee. I'm going to ask unanimous consent to enter in the record summaries of 4 cases here. The Kennedy bar exam lives on. Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Judge Ali Khan, I'd like to start with you. Tell me in one sentence what a judicial philosophy is. What do you think that means?
I think it's the set of principles that a judge brings with them when they join the bench.
How would you describe yours?
My judicial philosophy has 3 components, Senator. First, the humility to understand that the judicial role is quite limited. Legislatures enact laws, executives enforce them, but the only role of a judge is to apply the law to the facts of the case before them. Second, to make sure that all parties leave my courtroom feeling like they have been heard, knowing they have been respected, understanding that I have been well prepared and asked good questions. And finally, that I issue opinions that are prompt yet thorough and that are written in such a way that both litigants and pro se parties can understand.
What role should the text play when you're interpreting a provision of the U.S. Constitution or federal law?
The text is primary. You look at the text first. If it is unambiguous, that answers the question. That is well-settled Supreme Court precedent.
Where there's ambiguity, what do you look to resolve the ambiguity?
So when there is ambiguity, for example, in a statute, you would look to not just the text but the context. If there were, depending on when the statute was passed, looking at relevant dictionaries from the time to understand the public meaning of the words that were used. Also looking at the way those words are used in analogous statutes from the time. Ultimately, once you've exhausted text, context, history, dictionaries, you can look at canons of construction.
But the effort should involve trying to ascertain the meaning of those words at the time of enactment, if a statute, or at the time of ratification, if a part of the Constitution.
Yes, Senator. That's why you look to contemporaneous dictionary definitions.
Thank you. In 2021, you spoke on a panel at an event, I believe, honoring the 20th anniversary of the founding of the American Constitution Society. And in your remarks, you said, quote, "I've been able to think through my job, to carry out and live some of the values of ACS." Tell me, Judge, how did you carry out and live some of the values of ACS as Solicitor General and now as a judge on the D.C. Court of Appeals?
The values of ACS, as I understood them, were education and mentorship, and I try to carry those out both in my role as an advocate and now as a judge to make sure that I'm speaking to the next generation of lawyers, to make sure that I keep an open mind, stay current on interesting debates, stay current on the current state of the Supreme Court cases so that I can apply them faithfully to the cases that come before me.
Okay. And What other values might you refer to ACS? Are there others other than the ones you've just described?
I understand from Senator Blackburn there's a long mission statement for ACS. My involvement with ACS has always been on these types of panels where we're discussing legal issues, on mentorship events, when I'm speaking to the next generation of lawyers, particularly about opportunities in public service. And then oftentimes ACS and the Federalist Society will pair up at law schools to have different issues sort of aired and debated. I loved doing and going to those events when I was in law school, and I love speaking at those joint events because I think you're really getting a way of understanding the diverse perspectives of the law. I think that makes us all better students of the law. Obviously, as a judge, my role is just to look at the law and the facts and the cases that come before me. But for those that are still in law school, those that are exploring careers in academia and policy, I think these are interesting debates to be having.
Judge Mondlane, what can you tell me in one sentence about removal? Removal in the federal jurisdictional sense of a case filed in state court.
That if a case is filed in state court, at sometimes, senators, that one party will file a motion to remove the case for venue purposes to federal court, particularly with diversity cases. I mean, that was more so my experience with cases that I handled as a trial lawyer in state court, that sometimes lawyers on the other side would file a motion to remove the case to federal court for venue purposes, and then the case would proceed in federal court with diversity jurisdiction.
Right. Judge Oliver, what can you tell me about the Dormant Commerce Clause, what it means, what it stands for?
Thank you for the question, Senator. The Dormant Commerce Clause is considered the opposite side of the coin from the Commerce Clause. It prevents one state for attempting to gain a political economic advantage over another state by burdening that other state in a way that the home state's not burdened.
If it does so intentionally, that's one thing. What if it does so incidentally?
I think if it's incidentally, you might look at the text of the statute and determine it that way. It is part of Congress's ability.
The text of the underlying state statute?
Yes, Senator.
And so if it's written in facially neutral terms relative to whether it discriminates against interstate commerce, then is there anything left of the Dormant Commerce Clause at that point?
No, I think there's the important factor of intentionality as we're talking about competing economic interests.
Okay. Thank you very much. I see my time's expired.
Thank you, Senator Lee. I want to thank the panelists and all of their family and friends who came in support today. It is interesting when
Ms. Garnett, let's go to you next, if possible. On July 10th, the U.S. Attorney's Office for the Southern District of New York, which is the office where you now work as special counsel, announced that it was bringing charges against Dr. Gal Luft, who claims that in 2019 he gave incriminating information about Hunter Biden to the Department of Justice. About this indictment, his indictment, Dr. Luft said, quote, "I volunteered to inform the U.S. government about a potential security breach and about compromising information about a man vying to be the next president, and I'm now being hunted by the very same people who I informed," close quote. Are those charges against Dr. Luft, are they retribution for his willingness to speak out about Biden family corruption?
No, Senator. Those charges were actually returned in the fall of last year. The indictment was returned in the fall of last year. Mr. Luft was arrested in, I believe, Cyprus, and he was bailed pending extradition, and he fled from his bail.
Would you agree that they could be perceived as retribution for blowing the whistle on Hunter Biden?
I suppose someone could make that accusation, Senator, but I don't believe it's accurate.
Do you think at least the timing of those charges, I mean, wasn't it on July 10th that the U.S. Attorney's Office announced that it was bringing those charges?
Actually, Senator, the charges were returned last fall. The indictment in the United States, I believe, was unsealed on July 10th. I had no involvement with that decision. The indictment was unsealed in the United States at that time because it was determined, if, as I understand it, that Mr. Luft had fled from his bail in Cyprus and was not likely to be rearrested.
They were returned then. When were the statements made to the government? The underlying statements, were they made in 2019?
I had no involvement with that, Senator, so I don't know the details.
Okay. Given the concerns you've expressed about whistleblowers in the past, aren't you concerned about this whistleblower and about the appearance or the perception that he might have been the victim of retribution here?
I understand that some folks have expressed that perception. I can tell you from my experience in the case last year that that is not accurate.
Thank you, Mr. Chairman. Judge Lee, I'd like to start with you, if that's okay. A few years ago, you published an article in the Hastings Race and Poverty Law Journal. In that publication, you criticized the prison system based on the fact that the prison system, quote, relies heavily on a dichotomous sex-based means of classification, meaning, quote, prisoners are classified by their biological attributes rather than their gender identification. Do I take this to mean that you think that in some circumstances biologically male prisoners should be placed in prison facilities set aside to incarcerate women based on their identification?
Senator, that article or that piece was a summary of a panel which I moderated over maybe it was 13, 14 years ago. We had 3 panelists which focused on 3 different populations or segments of the prison population. The piece's purpose was to summarize the arguments and discussions that were raised by each of those panelists.
Right.
And so
that's why I'm asking the question about what you think. Do you think biological male prisoners should be placed in in prisons set aside for women?
Senator, that issue in terms of designations and so forth are live issues which are happening across the country in our courts. Well, important conversations with policymakers are having and which we are deciding and reviewing as courts. And so I don't want to make it appear as though I'm prejudging the case.
Okay, but you did comment on that, and that's what raised the question. And the reason I'm concerned with it is there are a number of women who have been concerned about this, including a number who are the survivors of domestic violence, who are currently suing Governor Gavin Newsom in the state of California to stop a California law that would do this. It would house prisoners based on their declared gender identity, thus allowing in many circumstances for a biologically male prisoner to identify as female and on that basis be placed inside a prison facility set aside for women. They've raised concerns there. So what would you say to those women? And what would you say to those who, as allegations are now being made, that say that they've been assaulted while in prison by a fellow inmate, raped by biologically male prisoners who were placed in a female prison?
Senator, I would say to them that every woman has a right to feel safe and be free of sexual violence. I would also say...
Including in prison?
Yes.
Okay.
And I would say... Sorry, Senator, I didn't mean to interrupt.
Well, no, that's okay. I just... It appeared to be a critique. If you're telling me it was not a critique, when on pages 227 and 228 of the aforementioned Hastings Race and Poverty Law Journal article, when you appear to be criticizing the prison system for the fact that it, quote, relies heavily on a dichotomous sex-based means of classification. Was that not a criticism by you?
As I said, it was a panel which I moderated, and with that piece was a summary of each of the panelists, their views, the issues that they were raising across the board with those 3 populations.
Okay. In a speech you gave in 2016, you stated that, quote, Korean American lawyers continue to fight against bamboo ceiling. You're not alone in this, and I took it from that, bamboo ceiling referring to limitations imposed on the basis of race. You're not alone in that, and what you described seems similar to some of the discrimination that was experienced by the Asian American plaintiffs in the Students for Fair Admissions case, in which the Supreme Court found that the law had been violated, the law and the Constitution had been offended by some of these programs. And yet the Asian Law Caucus, of which you're a board member, fought to maintain Michigan's affirmative action policies, policies that were found unlawful in that case. Do you want to explain these two positions that seem to be different? On the one hand, you're describing the bamboo ceiling effect. On the other hand, you're on the board of an organization that sought to perpetuate the very policies that were found to be discriminatory against Asians.
Thank you for that question, Senator. I was on the board of the Asian Law Caucus, I believe, over a decade ago or so.
Mm-hmm. So you're not on the board at the time that case was decided, in other words.
Okay. And in terms of the case, the Students for Fair Admissions, that is the law of the land. What that says is what I will be applying fully, faithfully, and without reservation.
Thank you. Mr. Chairman, can I ask one quick follow-up on this, and I'll be brief, relevant to that. In the Students for Fair Admissions case, the court concluded with the statement, eliminating racial discrimination means eliminating all of it, for the guarantee of equal protection cannot mean one thing when applied to a person of another color. If both are not accorded the same protection, then it is not equal, close quote. Do you agree with that statement?
I agree as what is emblazoned on the wall of the Supreme Court that there should be equal justice for all.
Thank you.
Senator Klobuchar?
Thank you very much. I'm going to focus.
To serve. Mr. Federico, let's start with you. During the Trump administration, during the early weeks of the Trump administration, there was an announcement made about some changing procedures for handling expedited removal proceedings. You made a rather lengthy blog post on the Federal Public Defender blog. I was a little surprised to see that, because as a federal public defender, this is pretty clearly outside of your domain of where you operate as a federal public defender. In fact, in the post itself, you acknowledged the distinction between criminal proceedings, including criminal proceedings, for example, for illegal reentry, which is a federal offense, and removal proceedings, which are civil proceedings, not criminal proceedings. In which you're giving, in this post, you're giving advice, as far as I can tell, to individuals who may become subject to expedited removal proceedings. And the post lists these practical tips for people who find themselves in that circumstance, telling them what to do, what to say, what not to say, what to do in advance, how to arrange things with their documentation, arrangements for their children, and so forth. And then you attach a separate document that gives additional advice, a document put out by the ACLU. Now, it is understandable why the ACLU might put out a document like that, but I was surprised to see you put this out on the website, on the blog attached to the official website of the Federal Public Defender's Office. Just tell me, why did you decide to write and publish this, and how is this consistent with your role as a federal public defender?
Senator, as I recall, I was asked to write that blog post by my office leadership, I think because we were getting a lot of calls about immigration matters. If I recall that blog post, also there is another lawyer who is an immigration lawyer whose name is on it as well. And I think we were careful to say, even though we do, as you noted, handle a lot of immigration matters in the criminal context, we were simply not taking any position on the policy changes, or if there were changes, simply stating what legal rights persons may have, which is sometimes what lawyers do.
Now, you are listed as the author of it. There's, in small text, very faint, there's some mention of a Melody Brannon. Is this another lawyer?
Yes, sir. Melody Brannon is the federal public defender for the District of Kansas.
Okay, and does she have a role in removal proceedings?
No, sir.
Okay, so it's also interesting that at the bottom of the post, you note, quote, that the document is not, quote, not meant to be and should not be relied upon as legal advice regarding immigration matters, close quote. So as best I can tell, this is more of just sort of a political statement. Does the Public Defender's Office in Kansas often make political statements or comment on political issues that are outside of its jurisdiction?
Senator, I'll speak for myself only, and I certainly don't or don't intend to.
And as someone who's employed by the federal government and an officer of the court, is it appropriate to issue documents that could be interpreted as facilitating the breaking of the law?
Well, Senator, certainly breaking of the law as a lawyer, I can never counsel clients to do that.
Okay, and how is this differentiated from that? So you're not, so that one of the things that I found interesting, when I discovered this, I went and found the blog. So I wanted to see what the website looks like as a whole and what the blog looks like as a whole. I couldn't tell right at first whether this was something operated independently by lawyers freelancing who happen to be employed there. It's not. This is attached to the official document. So this was published at government expense, operated on a government server. The rest of what I saw on there, obviously there's a lot of material there, but from my scanning through it, through material posted over years, the rest of it made perfect sense. As one who has long practiced in front of the 10th Circuit, it made sense to me. Here are the sitting dates for the 10th Circuit. Here are the hot issues affecting criminal matters before the 10th Circuit. Here are some issues related to motions to suppress based on this or that kind of evidence gathered in response to a search warrant, or things like that. This one was an aberration. It goes completely outside of your work on behalf of any clients and can be interpreted as advice to ameliorate the effects or perhaps even to facilitate the breaking of the law. How can we be certain that if we confirm you as a judge, you will be an even-handed arbiter of the law and not someone counseling or encouraging or facilitating someone in breaking the law?
Senator, I will do my absolute best, as it is my professional duty to be a neutral arbiter of the law, as I've done as a military judge. In regards to that blog post, again, all of our clients charged with criminal immigration offenses have corollary administrative immigration matters. So they're relevant to each other because it's the same client. As I recall, at that time, we were getting a lot of inquiries again about immigration matters. It certainly, and I believe there's another name that was immigration lawyer who was cited in that blog post as well. Our intention was merely to explain some of the differences between a criminal matter and an administrative immigration proceeding, and to state some of the rights people may have, which again is what lawyers often do, whether you work at a law firm, the federal public defender, or elsewhere, just stating legal rights.
Yeah. Thank you.
Senator Blumenthal. Thanks, Senator Blumenthal. Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here, for your willingness to be considered for these important positions. Judge Katabay, I'd like to start with you, if that's all right. A few months ago, in May of this year, you gave a presentation to the Oregon State Bar in which you included the following in your remarks. Quote, DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. Mr. Katabay, Judge, could you explain what that means?
Yes. Access to justice is at the heart of the work that I do within the courtroom, and ensuring that everybody is dignified and treated with dignity when they come into the courtroom, and for me to preside over those cases.
But you'd say that's the heart and soul of the judicial system, more than equal justice under the law, more than the Constitution, more than the law itself, or the job of interpreting the law fairly, where litigants before you have disagreements as to the law's meaning.
In the way in which, and in the context in which I was using the term and referring to diversity, was the idea and the ideal of equal justice under the law, that everybody, no matter what their background, beliefs, whatever that might be, that everyone is entitled to access to the courts and that equity.
All right, let's circle back to that one in a minute. The First Amendment's protection of free speech is foundational. It's been described as one of our first freedoms. It's been described accurately, I think, fairly, by many as being upstream from all of our other rights. and it has to be protected vigorously. And we also know that, that there are time, place, and manner accommodations that can go along with that. Among other things, there are special exceptions that occur where riot control measures are necessary due to an outbreak of coordinated overt violence. In a case that's been referred to briefly in the hearing today, but not much, this Bujarata versus City of Eugene, you're dealing with some interesting circumstances. You had riots taking place. There were 3 nights of terror in Eugene, Oregon, during the BLM riots of 2020, where, in your words, the following was going on. Quote, a crowd applying graffiti, lighting fireworks, and blocking traffic, throwing glass bottles towards officers surrounding a patrol car, smashing its windows and puncturing its tires, with the officers inside the patrol car, mind you. The group, quote, started fires in the roadway, attacked people and vehicles in the downtown area. Several businesses were vandalized and looted, and several officers were injured. You went on to state that members of the group carried heavy backpacks and bottles and were communicating via radios. So in response to this, the city implemented some riot control measures. They imposed a citywide curfew, one that lasted 7 hours. We had 3 rioters who were arrested during the curfew, and despite the Ninth Circuit precedent in the Mariotti case, the Minotti case, addressing a very similar curfew in Seattle, you decided that the Eugene, Oregon curfew was unconstitutional. Can you explain to me how, consistent with the Ninth Circuit precedent in the Minotti case, how does a 7-hour curfew through the middle of the night in the wave of such destruction and terror prevent ample means of communication? Can you explain that to me?
The Minotti case did provide guidance and assisted me in evaluating the legal analysis that I applied. There were 2 curfews that had been imposed. One was a downtown curfew, so there were geographic restrictions. That was not the curfew that was before me, nor did I find that unconstitutional. It was a citywide curfew that actually subjected everybody in the city, well beyond the boundaries of downtown, to out into the residential neighborhood, such that the application of that curfew, that citywide curfew, could have criminalized people's behavior of just trying to get home, well outside of any of the riots and the protests.
You've praised Ibrahim X. Kendi as someone who you like. He's an amazing historian and author, and you said that you would like to push some of Ibrahim X. Kendi's ideas even further. I'm sure you're aware. He's famous for saying, quote, the only remedy to racist discrimination is anti-racist discrimination. The only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Kendi also stated that in order to truly be an anti-racist, you have to be anti-capitalist. So I'd like to know, first of all, what would you do to push Ibrahim Kendi's ideas even further? And do you believe someone should be praising, someone who is currently a federal magistrate judge, be praising someone who encourages discrimination in any circumstance?
Senator, I don't recall having ever remarked that I want to push Ibrahim Kendi's ideas further. In questions earlier in this hearing, I clearly stated that the ideas that have been described here that have been attributed to Ibrahim Kendi are not ideas that are consistent with the 20 years in my public service, 16 as a judge, and the record that I have shown striving to apply the law, the Constitution, and Supreme Court precedent would not be consistent with this idea of supporting the ideas that you've described as Ibrahim Kendi's.
So you're saying that you have never said that you would like to push some of Ibrahim Kendi's ideas further?
So I don't recall having made that particular statement.
Okay. I see my time has expired. We'll follow up on these in writing. These are concerning one of the most fundamental laws we have that's embedded within our Constitution, is that governments can't treat people differently on the basis of their race, and that's why this is important to ask about. Thank you.
Judge Katabay, this case, Bujarata case, has come up several times. Can you tell me, was that subject to review by the district court? How did they view your ruling?
That was a case in which the parties had not consented, and it was reviewed by a district judge and adopted without opinion on the issue of the constitutionality finding with respect to the curfew. The follow-up finding and recommendation is still before the district judge and is on review.
I see.
Are we free to speak on both of these nominees, or just Mr. Katabay first?
It's your pleasure, whichever you
Thank
wish.
you. Thank you. All right, I'd like to, I'll be brief. Couple of things to point out on Judge Katabay. This wasn't just a passing comment. In addition to the other things that have been said about this, in a 2023 speech earlier this year to the Oregon State Bar, he said DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. So it's not just that he talked about that, and it's not just that he also said that we said this 2 years earlier in the Oregon State Bar Bulletin. As one of my colleagues mentioned, that he said, quote, "We have to set aside conventional ideas of proof when we're dealing with the interpersonal work of equity, diversity, and inclusion." These two things taken together, look, there are a million things that you could identify as the heart and soul of our judicial system. The rule of law, hundreds of years of Anglo-American jurisprudential tradition, the Constitution, our laws, the people, the personnel, the attachment to the rule of law itself. You could identify the heart and soul of the judicial system in a number of different ways. If you're going to define it as consisting of diversity, equity, and inclusion, it raises some questions. Why? Why isn't it any of the other things we mentioned? Why isn't it the law itself? But then when you add to that his earlier statement that you have to set aside conventional ideas of proof when we're dealing with the interpersonal work of diversity, equity, and inclusion. Why? The judicial system is the one place where you don't want people departing from traditional ideas of how you establish the truth. So why there? Why is that fair? What does that say about his ability to be a fair and impartial jurist if he's confirmed to this position? Now, in response to Senator Kennedy's questions at the hearing, he backpedaled and he said, "No, these are not obligatory. These are optional. It's an offer, not an obligation." Problem with that is we've got him on video speaking to the Oregon Bar saying the exact opposite. It is not voluntary, it is not optional, and you will be called on it. What does that say about his willingness to be fair and impartial to litigants and lawyers alike in his courtroom? All of this, together with his obsession with the writings of Ibram X. Kendi, which are themselves in so many ways, some of the writings, he explained that he wanted to take Kendi's ideas even further, when many of those same ideas are incompatible with basic notions of due process, equal protection, and the rule of law. I've also got some concerns with Judge Lee. Although Judge Lee hasn't published her radical beliefs quite as prolifically as Judge Katabay, she's no less radical. She authored an article in the Hastings Race and Poverty Law Journal in 2010, criticizing the methods that prisoners use to separate men and women. She doesn't like that prisons, quote, rely heavily on a dichotomous sex-based means of classification because, quote, prisoners are classified by their biological attributes rather than their gender identification. Yeah, there's some really good reasons why we have historically done that, reasons that have to do with the safety of prisoners, particularly the safety of female prisoners. It's well known in the prison system that you have different safety concerns in men's prisons than in women's prisons. Male prisoners behave differently than female prisoners. This is a significant issue. She previously served as a member of the Asian Law Caucus, and this is an organization that fought countless battles to preserve affirmative action in higher education. Race-based discrimination was recently found unconstitutional, appropriately so, by the Supreme Court of the United States in Students for Fair Admissions versus Harvard. And when Judge Lee was asked in her hearing before this committee if she agreed with the majority in Students for Fair Admissions, or if she stood by the position of her former organization that fought defiantly to preserve race-based preferences in the admissions process, she didn't answer the question. Rather, she said that she would defer. Well, we can only hope. We should be able to do more than hope. I oppose both of these nominees, and I'll be voting against them. Thank you.
The question is on favorably reporting the nomination of Mustafa Taber Kasubi to be U.S. District Judge for the District of Oregon. The clerk will call the roll.
Here, Ms. Hill, I'd like to start with you, if that's all right. As you know, in 2020, in the McGirt case, the Supreme Court held that in unique circumstances, major crimes committed in Indian country can be prosecuted only by tribal or federal courts. This ruling removed the state's ability to prosecute those crimes in those circumstances. Now, you strongly support the McGirt decision, and it's important to keep in mind that in Oklahoma versus Castro Huertas in 2022, the Supreme Court clarified that states retain the authority to prosecute non-Indians who commit crimes against others, even if those crimes take place in Indian country. Now, in one of your many critiques of that decision, you called Castro Huertas, quote, a very negative decision. And you said that, quote, Kavanaugh's opinion, which of course was the opinion of the court, Kavanaugh's opinion, it was terrible. To justify that critique, you came up with a hypothetical in which you stated that, quote, a non-Indian steals a car from an Indian, and that person can be prosecuted by the state. That person can also be prosecuted by the United States. They can be convicted twice for the same act and serve 2 sentences. That was part of your critique. My concern is that your critique here demonstrates a fundamental misunderstanding of how the double jeopardy clause of the Fifth Amendment works. I think most first-year law students can tell you that double jeopardy prevents separate prosecutions for the same offense when those prosecutions are brought by the same sovereign. A non-Indian who steals a car from a non-Indian, for example, in Utah, is properly subject to prosecution by both state and federal authorities, by the state government and by the federal government, because they are separate sovereigns in our system, just as in any other state in the United States. State governments are unique. They are unique independent sovereigns, separate and apart from the federal government. And the federal government is a completely different sovereign. This has been a line of authority. This has been a principle that's been clearly established ever since our nation's inception, certainly ever since we adopted the Double Jeopardy Clause in 1791 as part of our Constitution. So yes, McGirt presents a unique set of circumstances, an Indian committing a crime against an Indian in Indian country. But nothing in the Constitution prevents a state from prosecuting a non-Indian for their crimes, regardless of who the victim is. So in your view, do you disagree with the characterization of double jeopardy as I've just stated it? Do you disagree that the states are separate sovereigns from the federal government for purposes of the Double Jeopardy Clause?
I certainly don't disagree with that.
And if confirmed, would you follow the majority opinion in Oklahoma v. Castro Huertas?
I absolutely would. And given the practice that I've had, I've been following it for some time.
Your apparent desire to remove the state's authority to prosecute non-Indian offenders would, in my view, only weaken law enforcement's ability to remove violent offenders from the streets. And it's dangerous to place loyalty to any particular group over your loyalty to long-established principles of law or of the Constitution. So am I misreading your statement regarding Castro Huertas or the hypothetical?
I think that the full context maybe is not really reflected there, the full context of my comments. I can say, certainly on behalf of my client, I was critical of the decision in Castro Huerta because it was a decision that had other ramifications in Indian law outside.
Right, but I'm not talking about the other ramifications. I'm just talking about about double jeopardy here.
Right, I understand that. But those ramifications, that was some of the context of my criticism of it. I certainly believe and understand that I'm required to follow, will be required to follow the law if I'm so fortunate as to be confirmed to serve in the Northern District. And I understand the distinctions that if you have three sovereigns, that all three sovereigns could bring those claims, and there would not be a double jeopardy issue.
Okay, while you were while serving as Attorney General of the Cherokee Nation, did you state that you had no intent to enforce the law post-Dobbs?
I never said that.
Did you at any point say, I expect, and I think everyone expects, massive constitutional challenges to that law, just for your awareness, referring to those laws?
I was not referring to Dobbs. That was the decision of the court. I was talking about the Oklahoma law that had been passed relating to abortion post the decision in Dobbs, and that law was being challenged, had already been challenged in the courts. It was significantly newsworthy in Oklahoma at the time that the Oklahoma law was being challenged.
Challenged post-Dobbs on grounds that you believed were legitimate challenges post-Dobbs?
I couldn't say that they were legitimate. I just knew that there were likely to be many challenges to it. It was very contentious.
Okay. See, my time's expired. Thank you, Mr. Chairman.
Thank you, Senator Lee.